Hi, Chris Digirolamo from Maggiano, DiGirolamo and Lizzi. An important step in every case is to decide whether the case should be tried or whether the case should be settled. And oftentimes a client wrestles with which is the right thing to do. And obviously the best thing for that client to do is to speak to their attorney. It's not the same answer for every case. Every case is different. Every set of circumstances is different. And ultimately, the decision whether to try the case or not depends a lot on the treatment, the insurance coverage, whether or not the fault of the accident is easy to determine. So there are many criteria that go into what makes a case have to be tried versus a case that can be settled. Our firm really treats every case that comes in the door as if it will eventually have to be tried. So we take every step along the way to set the case up for trial. That way, if it has to be tried, we're ready. If the case can settle and should settle, then so be it. We've done extra work and that's fine. In today's society in New Jersey, there are varying degrees of, for example, in an automobile case, coverage available to a driver in the state of New Jersey. New Jersey auto insurance is some of the most expensive auto insurance in the country, and a lot of people can't afford to have the highest level of insurance coverage for fault. Unfortunately, the limit in New Jersey traditionally has been the lowest amount, $15,000 per accident. So if a person obviously gets catastrophically injured, and unfortunately the person that caused that injury has a small liability policy of $15,000, well, that case will settle typically very quickly and won't need to go to trial. If that person has a serious injury and the person that caused it has a limited amount of coverage, in New Jersey you can protect yourself and your own family by purchasing what's called underinsured motorist coverage. So in that event, you would collect the $15,000 from the defendant, and then, for example, if you have $100,000 in underinsured motorist coverage on your own insurance, you would be eligible to collect an extra $85,000 to total $100,000. If the injuries are catastrophic, if there are significant lost wages, if there are medical bills outstanding, those cases typically can settle very quickly if the insurance limits are low. What typically also drives whether a case can settle or whether it has to be tried is if the fault of the case is not clear. If each person is arguing they had a green light, for example, and they came to the intersection at the same time, and it's hard to determine who is more at fault, those are the kind of cases that typically you would have to try. A medical malpractice case where you're alleging that a doctor deviated from the standard of care, those cases most often are tried because the doctor will argue that he did nothing wrong, that sometimes outcomes are not what people want, but that the doctor didn't deviate from the standard of care, which is the requirement to prove fault on a doctor. In a fall down case, there's something typically in New Jersey known as comparative fault or contributory negligence, where the argument the homeowner or the property owner would make is the injury happened because the person who slipped and fell, for example, was not watching where they were going. They weren't paying attention. They didn't see that there was a condition that was what's called open and obvious. Very often, those are the kind of cases that also have to be tried, where neither side is willing to agree to settle the case. It couldn't resolve, and therefore it has to be put in the hands of a jury. So the long and short of it is, there's no set rule about whether every case should settle or every case should go to trial. It's unique to each case facts. But the best thing you could do, and what my firm does, is we prepare every case as if it has to be tried. And that's the motto, and that's the procedure we do at our firm.